We are on the record in cause number 23, CR 780, the state of Texas versus Brandon Dwayne Kirksey. He was indicted for the first-degree felony of aggravated sexual assault of a child. The court has received a message from the jury that the jury has reached a verdict in this case. I'm going to ask the bailiffs to bring the jury forth, and let's get the alternate first, and then they bring the main body of the jury in and receive the verdict. And the record shall now show that the jury is seated in the courtroom, and I'm going to ask the jury foreperson if you would be so kind to rise. Please stand up, and we're going to ask you to present the verdict in just a moment. The court has received a message from the jury that the jury has reached a verdict in this trial. Is that so, sir?
Yes, sir.
Is this verdict a unanimous one? That is, one that is agreed upon by all members of the jury?
Yes, sir.
Do any of the jurors disagree with your foreperson's representation? No disagreement. It does indeed appear to be a unanimous verdict. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish this verdict. The defendant shall rise. In cause number 23 CR 780, the state of Texas versus Brandon Dwayne Kirksey, we, the jury, find the defendant guilty of the offense of aggravated sexual assault of a child as charged in the indictment, signed by the jury foreperson. The verdict is received. It is made a part of the record for all purposes, and you may be seated. At this time, ladies and gentlemen, the court has received your verdict, finding the defendant guilty of the charged offense, the first-degree felony of aggravated sexual assault of a child. This brings us to a close of phase one of the trial, a bifurcated trial, two parts. We are going to proceed next with the punishment phase of the trial. Please be mindful you are still under all the instructions that have been given to you previously. All right. There is the second, before we break, there is the second paragraph here, which is not going to be relevant in this matter at this time.
Correct.
All right. Ladies and gentlemen, we're going to take a break for lunch. Can all of you be returned back at 1:50?
Judge, can you do that till 1:30?
I've got a better idea. How about 1:30? Please, if you go with other jurors, talk about the weather, everything else, not about this case. But I give these instructions you are required to follow until the end of the case. And let's return back at 1:30, 1:30. All right. Everyone else remains seated while the jury exits first. Thank you. Yes, sir.
Am I required to return, Your Honor?
Yes, sir. Thank you until the end.
Great.
Thank you. One other thing, for the record, we cannot make outbursts in front of the jury. That is inappropriate. And if you cannot compose yourself, you must remain outside. These are difficult for everybody, but people are not allowed to be emotional in front of the jury. That can only be determined to be a possibility of someone trying to influence the jury. We still have the punishment phase. You're going to stay outside, ma'am, until the conclusion of this trial. Thank you. I'm sorry, you can't unring a bell. This jury has already seen and heard you, and that can affect them. And this court can't allow that. The jury has to be focused on its job, not listening to people who are making outbursts, and that is inappropriate. You will remain outside. Thank you. We're in recess. One other thing, before I leave, Mr. Kirksey, anytime you want to bring him back to help counsel you, you may. Right now, you're representing yourself, and there are serious disabilities to doing that when you're not legal expert and has tried cases like him. If at any time you wish to get him back to represent you, he's standing by. If any time you want Mr. Wilkerson to get back to represent you, you let me know so you can be guided. Because there's an old saying, it's a foolish person who represents themselves. And that I didn't make that up. It's a fool who represents himself in a criminal trial because it disfavors you for many reasons. And there's so much at stake at every trial in this room, but defendants representing themselves seldom do well because there's so many dynamics that require education, law school training, and experience that go into trial work that just people who aren't who don't do this for a living aren't able to do it. What do you do for your living? I mean, when you were Freeman, what's your abilities?
Carpenter.
Let me tell you, I'd probably saw off my hand first thing. See, that's why I would have to have something. I couldn't do that right off, and I certainly wouldn't be able to make something that's an art form without experience and training and being careful about the tools that you use, since those can be lethal. The same thing applies here. So anytime you want him to help you, well, you can. Okay. But please be mindful of it. Think about it.
Yeah, sure.
All right. And let me know if you change your mind.
I do. I
Sir?
do. I change my. I like it too. I just want.
All right. All right. He wants you to help him.
I just want to be heard, man. That's it.
So y'all, Mr. Wilkerson, go go back there and discuss whatever he needs, because we still have a second phase to deal with.
And that's the question, is it, I mean, I'm standby, but do I do punishment or am I just here to
Y'all talk about it.
advise him?
Y'all talk, he's wanting you to help him find out what that means and then pass it to me. And if he wants you to continue to represent him for this punishment phase, then I'm going to ask you if you'd be so kind to do that, to help him.
Yes.
Thank you. We're in recess.
Yep. That's the question. Oh, yeah. I can't have it in chair.
Thank you. All right, we are in recess until 1:30. And the defendant is present. All parties are present. Mr. Kirksey, we have received a message from the jury that the jury has reached a verdict in this punishment phase of this trial. And whatever the verdict is, we'll find out about it all at the same time. Please be careful about any outbursts that may be made. That would be inappropriate, and we don't want anybody disciplined because it is an offense to make an outburst in court. We've reached a verdict in this